One can think of the Heifer Commission, which was appointed by President Mbeki around 10 years ago. That was an important matter. It was investigating claims that there had been counterintelligence operatives working within the ANC, and that the impact of their work was still impacting on the democratic governance of the country. The point about commissions of inquiry is they tend to be rather rare things, and they should be rare things because they're expensive, but more importantly because they're an exercise of presidential choice. They're appointed by the president under his powers under the Constitution, and they should be appointed only when dealing with issues of the greatest public importance. The other judicial inquiry, which was the one that President Mandela set up in the 90s, was a slightly curious one in the sense that it was about sport. Sport, of course, matters a great deal to South Africans, and it was about rugby in particular, and about the running of rugby. And that was an inquiry that was established to look into the running of rugby at a time where there were profound issues of transformation and leadership and so on.
Mm-hmm. And there have obviously been quite a few, but just as you're speaking about sport, there is one that has now been mooted to look into sports by the Sports Minister Fikile Mbalula. But just to go through some of them, there's obviously now that we're talking about the Marikana Commission of Inquiry, there's going to be the Arms Procurement Commission, there was a Donor Commission, there was the Jimwala Commission, there was the Van Zyl-Slabbert Commission, there was the Gampepe Commission, but there have been so many. But the question that really comes to the fore for many people is, what has been the purpose of these commissions of inquiry? I did mention in the introduction that some of the criticism launched against them is that they take an inordinately long time to deliver on their mandate, and that despite the recommendations and reports that are submitted, they're seldomly implemented. Is that a fair criticism?
I don't think it is. Can I be pedantic, and forgive me for this for a moment?
Go for it.
But a couple of the commissions you just mentioned were not judicial commissions.
Mm-hmm.
The Jimwala Commission, for example, was actually a deployment of a provision which enables the government to set up an internal inquiry into, in effect, its own decision-making. And in that case, it was about the decision of President Mbeki to suspend the then National Director of Public Prosecutions. Now, that's a good example of a commission. It wasn't a judicial one, but it was one that actually had to deal with a very important matter. When the President takes such an important step as to suspend the National Director of Public Prosecutions, it's inevitable that there will be public concerns, public interest in why such a drastic decision has been taken. Was it an unlawful interference in the operations of the prosecuting authorities? That would have been the sort of issue that at the time dominated the public discourse. Now, what Jimwala found about, for example, the conduct and integrity of the then Director General of the Justice Department, Menzi Simelane, later was very, very significant in terms of the court finding it appropriate to overturn President Zuma's appointment of Advocate Simelane as the National Director of Public Prosecutions. You'll recall that the court found that that was an irrational appointment, given what Jimwala had said about his integrity and his probity. But turning briefly to the two commissions which you mentioned, which are currently underway, which is the Sariti Commission into the arms deal and the Farlam Commission into Marikana, these are at a higher level because they are judicial appointments, judicial commissions with judges, former or present judges, leading them. Judges have, by virtue of their position on the bench, they have higher levels of authority, and judicial commissions are given greater powers.
Just before we go back to the Commission of Inquiry looking into the NDPP and, of course, the Advocate Vusi Pugoli, I'd like to just understand the distinction between a judicial commission of inquiry and, as you say, the normal commission of inquiry that has been appointed to look at a specific issue.
Yes. Well, a judicial commission of inquiry is something that has to be appointed according to the law. I mentioned before that the Constitution gives the President power to appoint a judicial commission of inquiry, and I think it generally said that is an exercise of presidential power as state president rather than a governmental decision as the cabinet. But that may be debatable. What's important is that when the president makes that choice, he does so bearing in mind the Judicial Commissions Act. There's an act of Parliament which governs this. You can't just wake up one morning and say, I'm going to appoint Judge X to look into something. There's law which determines whether it's appropriate or not. And that act also then gives the Commission, through the presidential appointment, considerable powers and authority as to how it goes about its business. All commissions will be given terms of reference, and the terms of reference are really important in understanding how far a commission of inquiry can go in its investigations. And that's why when a commission is set up, there's always a lot of attention focused on the terms of reference. And indeed, with both Seriti and the arms deal on the one hand, and Farlam and Marikana on the other, generally speaking, people are happy with the terms of reference. President Zuma gave them broad terms of reference, I think, and people are generally satisfied. The focus of criticism subsequently has really been about the strategy of the commissions, their funding, which is terribly important. They've got to be properly funded, and there's a terrible argument going on at the moment, to which you'll no doubt turn, in relation to the funding of the lawyers involved in the Farlam Commission. And, of course, lastly, the way they go about their business. And you haven't mentioned it yet, I'm sure you'll come to this, but last night I understand that Judge Lagarde has resigned from the Seriti Commission into the arms deal, primarily because of his concerns about the way in which the Seriti Commission is proceeding with the investigation. And that's very, very serious, and it undermines, I imagine, public confidence in the Commission and its ability to get to the truth.
Well, I was going to get to that, the issue of capacity, the resources, and not only financial, but also in terms of the staff complement that is given to the commissions of inquiry. But let's start with the financial resources. When we were looking at why there's this big argument and the delay, the fact that the state was repeatedly saying that we're not obliged to allocate funds for this commission of inquiry. But if it's a judicial commission of inquiry and it's meant to be inclusive, is this not one of the considerations that should be taken into account when forming such a judicial of inquiry and its terms of reference?
Absolutely. And if a government is serious about a commission of inquiry, and bear in mind what I've said about the rarity of an appointment, you only appoint a judicial commission of inquiry when you perceive there to be an issue of absolute high political and public interest and importance. And at that point, you are committing to a full investigation. You're committing to a comprehensive investigation. And you have to therefore match the resource commitment to that public intent. You can't go off half-cocked. You can't have a half commission of inquiry. That would be counterproductive. It's likely to undermine confidence in commissions. It's likely to lead to accusations, which are now surfacing in relation to both Farlam and Seriti, that the government isn't actually serious about getting to the truth. And that's terribly damaging then for not just the commission, but also for the public interest in getting to the truth. So although these things are expensive, you have to commit to them and accept that they are a public investment in truth-finding and a public investment in learning about the past in order to strengthen the ability of the government and society to govern effectively and accountably in the future.
And as I mentioned, that I want to come back to the Ginwala Commission of Inquiry, especially on that aspect that you're talking about, truth-finding, the recommendations that were made. But to just the last point that you made now, does it not bring about the fundamental question about these commissions of inquiry, the intention behind it? Are they just a placatory move to say to the citizens that we take note of the subject and we're so serious about it that we're forming a commission of inquiry? Or is it a push effect that if you don't set up a commission of inquiry, you're deemed to not be taking the matter seriously?
So, Peter, I think that's exactly the right question to be asking, if I may say so. And here it's worth pausing to consider the background behind the two commissions, Farlam and Seriti. With Marikana and Farlam, as you said in your introductory remarks, in a sense, there was no choice. It was an issue of such importance. It was such a terrible event. It was so tragic. And the public outcry and dismay at the shooting of so many people in cold blood, or apparent cold blood, I should say, immediately deserved a judicial inquiry. I think President Zuma had little or no choice on that occasion. However, with Sariti, bear in mind, the Sariti Commission is looking into events that are over 10 years old, in a sense 20 years old, because he's got to go back to the roots of the arms deal. The arms deal was reached only in the late 90s, but history suggests, or what evidence we have available now already, suggests that the piranhas were circling as early as 1989 in order to try and induce or bribe decision makers within the ANC into entering into these very expensive arms procurement contracts. And so there's a mountain of evidence to go through. Now, with Sariti, Zuma didn't really want a commission of inquiry, I would venture to suggest, partly because he has some interest in the matter himself, and indeed one of the reasons he was initially fired by Thabo Mbeki in 2005 was because of the allegations that had surfaced in the trial of Shabir Sheikh, his former business partner, where the judge unearthed evidence that suggested that Zuma may have been a beneficiary of some of the side contracts that were connected to the arms deal. So I don't think he's terribly eager for the commission to uncover everything. Moreover, it may well be, as Andrew Feinstein, the former ANC MP, has suggested, it may be that the ANC has a considerable stake in the truth behind the arms deal. There's been many suggestions from Feinstein and others that the ANC was bribed as part of that process, and that significant ANC leaders such as Joe Madize, the defense minister in the 90s, were the recipients of very substantial bribes. So there are some heavy political interests at stake with the arms deal inquiry, and it took an application to court by the activist Terry Crawford Brown a couple of years ago to induce a decision by President Zuma to appoint the commission. Just weeks before the Constitutional Court was to hear the matter in late 2011, President Zuma, I think on the basis of prudent legal advice, decided to relent and take control of the matter himself. I think the view was politically better that I choose the terms of reference and so on, rather than the Constitutional Court. And he at that point appointed the commission, and he discussed the question of who should chair it with a number of candidates, including former Chief Justice Ngobo, but ended up with Justice Sariti. And quite frankly, Justice Sariti is still trying to convince us all that he's capable of doing the job required.
We're taking your calls. Let's go to Dorong in Spruitview. You say the commissions only serve the people who set them up.
Indeed, Billy Dumel. And then to Professor Richard Kaland. Yeah, I saw Terry Crawford Brown from a very youth age, and now he's getting older. You know, he's been fighting this matter, long, I think now for nearly 2 decades. And then it's challenging, so in attempting to respond to your commission, to your question whether they serve the purpose. Because, for instance, Truth and Reconciliation Commission, one of the famous that we had in this country, for me, I think it has not served its purpose, because there's still a lot of people who were closed out of the Truth and Reconciliation Commission. Hence, now this thing is beginning again to come back to haunt us. And indeed, all other commissions from Khampepe, Siriti, Ginwala, and then the Marikana Falams Commission of Inquiry, which my government is refusing to pay the lawyers. And I don't understand for what reason, because this thing has got a public interest. It's a judicial commission of inquiry. And with respect to the one now that is being set up for the arms deal, obviously that commission can be manipulated or even stifled to serve the purpose of those who want to remain in power, by making sure that they want to remain in power, by making sure that they will get people that they don't want them to go out. So we must be careful, and it's our money here. It's not a person's money from his or her own pocket. It's our money. Pay the lawyers at Marikana.
All right, thanks, Dorong. Mac in Cape Town, you asking why commissions of inquiries instead of investigators? What do you mean, Mac?
Yeah, because I mean, what does it say to our security departments like the SAPS or the trained investigators, even the Hawks? Okay, I've part of my question could have been partially answered when he, one of the guests there said that there's a process that is going through about the hawks and all that, which is going through Parliament and all that stuff.